Excellent. Good afternoon, everybody, and thank you, Gauta, for the kind introduction. And thank you to Oil Spill India for the invitation to come and present this week. It's both an honour and a pleasure to do so. And thank you, Chiara, for your excellent presentation, which has absolutely set the groundwork for my own. So for the next 15 minutes or so, I'm not going to talk too much about P&I clubs, who they are, what they do, or about the international group of P&I clubs. You heard quite a bit about P&I yesterday in the presentations and speeches given by my colleague, Sue Watkins. If you'd like to know more about P&I, then please, there's still time to come by our stand in the exhibition. I will, however, be talking about the role of the P&I clubs in the IMO liability and compensation conventions for oil pollution damage. So the 1992 Civil Liability Convention that Chiara mentioned, governing liability and compensation for pollution damage from spills of persistent oil cargoes, and the 2001 IMO Bunkers Convention, governing liability and compensation for pollution damage from ships' bunker fuel oil. The 1992 CLC, it's in force in 146 countries around the world. That includes India. The Bunkers Convention, it's in force in 104 countries around the world. As we heard yesterday, unfortunately at the moment, that doesn't include India. I'll be talking a little bit about the certification regime under these two conventions, how you evidence that convention insurance certificates are in place, and then I'll be talking about two voluntary industry agreements, the Small Tanker Oil Pollution Indemnification Agreement, STOPIA, and the Tanker Oil Pollution Indemnification Agreement, TOPIA. So how does P&I cover underpin these two IMO liability and compensation regimes governing pollution damage from persistent oil cargo spills, CLC, and bunker fuel oil spills, the Bunkers Convention? Both of these conventions contain very similar key provisions. Both of them provide that the ship owner of the spilling vessel is held strictly liable for pollution damage under the scope of the conventions, meaning that the owner of the spilling vessel is liable to pay compensation for losses arising from pollution damage, irrespective of any fault on their part, subject to a few exemptions under the conventions. Both conventions require the ship owner to maintain financial security. Normally that will be insurance, and normally that will be in the form of the vessel's P&I cover in order to cover that owner's liabilities under the two conventions. Now, the insurance provisions of these two conventions, CLC and Bunkers, they apply to different types of vessels. CLC requires all tankers carrying more than 2,000 tons of persistent oil cargoes to have financial security in place to cover the owner's liabilities. The Bunkers Convention is different. The Bunkers Convention requires all vessels excess of 1,000 gross tons to have insurance cover in place to cover the owner's liabilities. As Chiara mentioned in the context of CLC, both the CLC and the Bunkers Convention provide for rights of direct action against the vessel's insurer, by which we mean if a person has suffered a loss that falls under the scope of either of these conventions, that claimant can bring their claim for compensation for pollution damage directly against the vessel's insurer, normally the vessel's P&I club. They do not have to bring that claim necessarily against the owner of the spilling vessel. they can go directly against the P&I provider that is providing the financial security for that vessel under either of these two conventions. That is what we mean by rights of direct action against the insurer. Both of these conventions have state convention insurance certification regimes, and all vessels falling under the insurance provisions of these two regimes are required to carry on board at all times either a CLC state convention certificate and or a bunkers convention certificate. Those certificates can only be issued by states parties to the conventions. Those certificates are normally issued by states parties to the conventions, which will normally be the vessel's flag state, upon receipt of a financial guarantee certificate issued by the insurance provider that is providing the financial security required by either of these two conventions, normally the vessel's P&I club. And those insurance financial guarantee certificates are known in the industry as blue cards, CLC blue cards and bunker convention blue cards. The P&I club will issue for that vessel a bunkers convention or CLC blue card. And the owner of that vessel will then present that blue card to their flag state, if their flag state is a state party to the convention, or if their flag state is not a state party to the convention, either CLC or bunkers, then the owner will need to present that blue card to a state party that isn't its flag state. Upon receipt of those blue cards, then the state issues its state convention certificate that these vessels are required to carry on board at all times. So hopefully that just gives you some ideas to how P&I clubs and how P&I cover underpins the key provisions of these two conventions governing liability and compensation for oil pollution damage. These key provisions that are contained in these conventions cannot be replicated in statute other than through accession or ratification of these regimes, because they have been negotiated, adopted, and agreed at the international level to apply through international rules and regulations. So we have CLC in force in India at the moment. So the P&I clubs are issuing CLC blue cards to tankers carrying more than 2,000 tons of persistent oil cargoes that are Indian registered. And for port state control purposes in India, for any tanker carrying more than 2,000 tons of persistent oil cargo and entering an Indian port state control should be checking that they have a state convention CLC certificate on board. As we said now on a number of occasions, the Bunkers Convention is not in force in India, but if India did accede to the Bunkers Convention and it was in force, then the P&I clubs would be issuing Bunker Convention blue cards to vessels greater than 1,000 gross tons that were Indian registered. And also Indian Port State Control would be checking every vessel over 1,000 gross tons that they had a state-issued Bunker Convention certificate on board. But that isn't happening because India hasn't acceded to the Bunkers Convention. If a Bunker Convention or a CLC blue card has been issued by a P&I club member of the international group clubs and the international group have established means by which anybody can check whether a blue card has been issued to any vessel entered in one of the group clubs. All of the 13 group clubs have ship search facilities on their websites. They are publicly accessible. And the international group has established a ship search facility on its website. That's publicly accessible as well, and you can type in the name of any ship entered with any of the 13 group clubs into that ship search facility on the group's website. And if it is entered with one of the 13 clubs, then its name and details will appear. And I've just highlighted on the screen here the ship search facility site on the International Group's webpage, www.igpni.org. You can go to the ship search page. And I've just given an example on the screen here. The vessel, the Jag Lalit, which is entered for P&I cover with the steamship P&I Club. The name of the vessel is then a hyperlink through to the ship search page of that club, providing P&I cover to that tanker. So in this case, if you clicked on the Jag Lalit, it would take you through to the details for that vessel on Steamship's website. And then it will tell you whether Steamship has issued for that vessel a CLC and/or a Bunkers Convention Blue Card. This process, this procedure, has actually been acknowledged by the IMO in a set of guidelines for states on acceptance of blue cards. Those guidelines are contained in IMO Circular Letter number 3464. I've just included on the screen there where that procedure in those guidelines is accepted. And if you can see it, little Roman 1 at the top, it states that states parties to any of the relevant conventions should accept blue cards issued by a member of the International Group of P&I Clubs if it is possible to verify that blue card from the club's websites. I've just highlighted how you can do that. So Chiara ran through how the three-tier compensation and liability system works for oil pollution damage in respect of persistent oil cargo spills. CLC, the first tier of compensation and liability, ship owner liability backed by their P&I club. Second tier, IOPC fund sitting on top where the fund is in force. And then the third tier of compensation, the supplementary fund, where that is in force, which at the moment is only 32 states around the world. That is how it looks under the conventions. In practice, however, if it is a tanker spill involving a tanker that has P&I cover with one of the international group clubs, in reality, the limits and the payment of compensation is slightly different. And it's slightly different because of the two voluntary industry agreements that I mentioned at the start of this presentation. On the one hand, Stop Here, and on the other hand, Top Here. Stop Here provides that for tankers entered in an international group club up to 29,548 gross tons, their maximum limit of liability will be increased to 20 million SDR. It's about 29 to 30 million US dollars. Stop Here was agreed by the membership of the international group clubs in 2006 to recognize the fact that the 1992 IOPC fund was paying a disproportionate amount of compensation in small tanker spills. So it sought to redress that balance between the two paying parties under the system, ship owners and P&I clubs on the one hand, and oil contributors on the other, to try to ensure that they would be paying and continue to pay roughly an equal share of compensation under the wider system. Top Tier applies for the purposes of the supplementary fund protocol, the third tier of compensation. And Top Tier provides that in the event that the supplementary fund pays a claim involving a tanker entered with one of the 13 international group clubs, the ship owner and the P&I club will pay 50% of that claim. That is to recognize the fact that the supplementary fund is only funded by oil contributors. So again, it seeks to redress that balance to ensure that there is equal payment of claims by the two paying parties under the system, oil contributors and ship owners and P&I clubs. So these are voluntary agreements. I'm not talking about statute, I'm not talking about regulations. These are voluntary agreements that bind the ship owner members of the international group clubs. They apply to tankers only entered for P&I cover with one of the international group clubs and on a mutual basis. So the effect of stop here is essentially that the 1992 IOPC fund in small tanker cases will pay less because ship owners are paying more than their limit of liability under CLC, meaning that Indian contributors will be paying less in small tanker spills. But it only applies where the 92 Fund Convention is in force. So it applies in India. TOPIA, as I mentioned, it effectively means that the supplementary fund will be paying 50% of any supplementary fund claim, and ship owners and P&I clubs will be paying the other 50%. But it only applies where the supplementary fund protocol is in force. And that protocol is not in force in India at the moment. So we have CLC fund in force in India. That means that in the event of a small tanker spill in India, it's a CLC fund case. Stop here, it will apply. Supplementary fund protocol is not in force in India. It's only in force in 32 states around the world. But because it's not in force in India, that means that TOPIA would not be applicable in a tanker case in India either. So we've heard various statements over the last few days, particularly in relation to ITOP statistics and data, that the large number of oil tanker spills has significantly reduced over the years. That has to be a positive thing. My colleague Sue Watkins mentioned yesterday that we're definitely seeing more bunker spills nowadays than spills of oil cargoes carried by sea. In relation to these conventions, we are not aware of any better statutory protection for a coastal state when it comes to compensation and liability. So CLC fund and the supplementary fund protocol are incredibly important. That 2003 supplementary fund protocol provides even greater protection than CLC fund. But we shouldn't forget the Bunkers Convention as well for the reasons mentioned. So we as an insurance industry, P&I clubs, the international group of P&I clubs, we very much support Indian accession to both the 2003 Supplementary Fund Protocol and also the 2001 IMO Bunkers Convention. Thank you very much. I hope that was helpful, and I look forward to answering any questions in the Q&A.
Thank you very much.
Oil Spill India 2022 is dedicated to the Honourable Prime Minister's Swachh Bharat Abhiyan and Clean Seas.